All right, we're going to continue on with Chapter 5, 5-3, Negligent Torts. Pretty hard to see here. Okay, we are going to answer the essential question here. What constitutes neglect? Neglect is another version of the word negligence. So what constitutes neglect? I'm asking you. If you are a neglectful person, explain a way that you might be neglectful or how you might be showing neglect? No, not nice. It's the other way. More than mean. Not exactly push people away. Can't see upside down. Okay. Well, I'll tell you what. We'll do the next slide, and then you can tell me what you think. Okay. So what's your verdict here? Britt was driving home late one rainy night after drinking alcohol all evening. Okay. With only one working headlight, she raced down residential streets, which means streets where people live. Okay, houses, homes. It speeds up to 60 miles per hour. Meanwhile, Yi was slowly backing out of her driveway. Okay, she failed to look both ways when she should have done so. Okay, but Britt rammed into the right rear of Yi's car. Both Britt and Yi were both injured in the collision, and their vehicles were damaged. So we have a rainy night. We have not the best driving conditions. We have speeding, going 60 miles an hour in a residential area, which is usually 25 to 35 miles per hour. And we have one working headlight, okay? I'm telling you, Britt was a neglectful person here, okay? She was negligent. How was she negligent? What does negligent mean now? Doing something wrong. Yes, okay, so she was not using proper care. Okay, so she was not demonstrating the proper care. If I'm a neglectful parent, I might not seatbelt my children, or I might not make sure that they get to school, because then I'm being neglectful. I'm showing neglect to my children by not caring for them properly. Okay, so that is the question. The essential question was, what constitutes neglect? Okay, or okay, it would be not showing the proper care, okay, that is required. You not showing the proper care of Aaron. Okay, then our next question is, what is the proper care that is required of, classmates? What is it that you need to do, Nick, to show proper care to Aaron? Okay, respect him, respect his space, respect his things. Okay, what else? If you have a contagious disease and you come to school, are you showing him proper care by coming here and sitting here and spreading germs all over on him? No, okay? You would not be using, you would not be demonstrating the proper care. That would be neglectful. Who else would be responsible for your neglect if you came to school with a contagious disease? Okay, perhaps your parents, which is sort of a branch of you, and who else? The school might be responsible for not, if they see you come in with, say, pink eye, and you come in, you know what conjunctivitis is, pink eye, okay? And they see you and you have all this goopy goop coming out of your eyes, and, this is a little more difficult at a high school level, because hopefully you know how to keep your hands to yourselves. But in the elementary school, if a kid comes to school with pink eye, the teacher will send them to the office, to the nurse, who will send them home, because it is a contagious disease, and it is something that, the proper care would be to make sure that it's not spreading to other kids. Okay? So that's what constitutes neglect, is not demonstrating the proper care in this situation that is called for. Okay, so in our example here, who will have to pay the damages for the injuries, Okay, and the property damage that was sustained in the car accident. So we have Britt, she was drunk, she was speeding, it was rainy, she had one headlight, so Britt is big time at fault here. Okay, and Yi is slowly backing out of her driveway. She does not look both ways though. Okay, so therefore she doesn't look both ways and she doesn't see Britt come flying around the corner with her one headlight in the rain. Who is responsible here? Are they both responsible? Is one responsible? Okay, so for sure, Britt is responsible in this case. Britt would be responsible, or Britt's insurance, hopefully she has some, for paying for the injuries and the damages in the car accident, okay? And then Yi would also be responsible for a portion of it because she failed to look both ways when she backed out of her driveway. So we are, as drivers, like we've discussed before, we're responsible for knowing where we are, where the things are around us, okay, and knowing the laws in the area where we're driving. All right, that's our duty of care as drivers. Okay, so there's our little our example. Okay, a phrase that is frequently used in tort law is reasonable person standard. You will hear this again and again. Okay, our little example here says, for me, that was totally reasonable. Okay, he shot the guy. Now, this is supposed to be ironic or sarcastic because it's demonstrating that what's reasonable for you and what's reasonable for me might be very different things. So we have this hypothetical person in society who exercises average care. They're not Joe Amazing running around doing everything for everybody. Okay, Joe Amazing, trademark. It's a real person. Okay, but they are exercising average care, judgment, conduct, okay, in average situations. So they are going to be the standard by which other people are judged. This hypothetical person, not a real person. Hypothetical, do you know what that means? Hypothetical? You used to? Would it fall out of your head? Oh. Stoner, you want to help us out, hypothetical? Sure. What does hypothetical mean?
Like fictitious or pretend or make believe.
Beautiful. Okay. That's all I needed. You need me? I sure do. Hold on one second. All right. Okay, so we have this reasonable person standard that is based on a hypothetical person, an imaginary person that's not real, because the difference of what is reasonable to you and me and all different people have different levels of reasoning. So we have this hypothetical person, okay, and this is the standard that they use to judge what is expected in tort cases. Okay, in most cases, persons with greater than average skills or special duties to society are held to a higher standard of care. So the example is a physician, okay, who has exceptional skills. A physician, a doctor, has more skills than the average bear, or even a doctor bear. Anyway, they are expected to do additional things that you and I would not be expected to do. If you are a first responder, okay, or if you are certified in first aid, CPR, etc., you have an expectation to administer those skills, those specialized skills in circumstances where a person would need them. That is an expectation. Okay, if you don't do that, that would be a breach of your duty of care. You would have failed to, provide CPR services or Heimlich services, that kind of thing. Okay, first responding services. Yes, sir. If you don't do it, if you do not provide the services? If you provide the services and you are not certified, and you save someone's life, can you get in trouble? No. What we have, they now have what's called a Good Samaritan law, which has protected, it now protects people because it became an issue that people would oftentimes, when you are performing the Heimlich maneuver, ribs will be broken. Same thing with CPR. Okay, when you're doing the resuscitation, okay, and the compression to the chest, ribs will be broken, and there can be internal injuries that are sustained, that kind of thing. Those people or the families of those people occasionally would, yes, okay. So, well, perhaps, but now we have a Good Samaritan law which says if you go that extra mile to perform these services, you will then be protected by the Good Samaritan law. It's so that we are able to still do good things and not have the threat of litigation brought upon us. Okay, so no, you cannot get in trouble if you are not certified in these things and you attempt to save someone's life. I would say, as a kindness, I would say it's always best to try to help a person in need. But anyway, okay, so that is reasonable person standard, and we are going on. Okay, so we have first in our negligence, we have proximate cause. So this exists where the plaintiff is injured as a result of the negligent conduct. Remember, in tort law, when we speak of the plaintiff, that is the person who has received the injury. Okay, so the plaintiff is injured as a result of the negligent conduct, and the plaintiff's injury must have been a natural and probable result of the negligent conduct. Okay, we have to be able to make some kind of connection. Okay, in order for the defendant to be liable, the plaintiff must establish that there was negligence, okay, and there was proximate cause. Without one, would the other have occurred? Okay, so in a lot of accidents, we have more than one proximate cause because there could be more than one thing going on here. I'm going to move on to just hit this example, and then we'll come back to the other. Okay, for this example, there are two proximate causes. We have a plaintiff driving down the road, and they are suddenly cut off by a person who is running through a stop sign on a side street. Interesting. It's March. Okay. So a plaintiff is driving down the road, suddenly cut off by a person who runs through a stop sign. Plaintiff slams on the brakes and is able to avoid striking the car. However, the plaintiff is rear-ended by another driver who was not paying attention to the events in front of the car. Now, in this example, we have a three-car pileup. So we have a car here that was hit by this second car and then the third car. Now, what we're going to assume in this case, as you're looking at the picture, is that this is the car. It probably stopped and avoided hitting this other car. However, this guy back here wasn't paying attention in the truck, and he hit the second car, which then hit the third car. Okay? So we have a couple proximate causes. In our example here, the guy who ran through the stop sign, that was one cause. And then the third car that was not paying attention, that was the second cause. Okay, so we have two causes that caused this accident. Okay, the plaintiff, in the meantime, is just doing what she does. She's just driving along, minding her business, being respectful of the laws, and not breaching anybody's care. The breach occurred here when this guy ran the stop sign. He breached her duty of care because he did not take care to make sure that she was safe. He just ran through the stop sign. He broke the law. And he also, he was acting negligently. And then this guy is not paying attention and therefore rear ends the car. Okay, so we have two things going on, which have led to this, incident where her car has been damaged. Okay, do you understand the idea of proximate cause? It's not directly the thing that caused the accident, but we can make a connection. Okay, we can make a connection between the injury and the cause. Okay, you don't understand? Do you understand? You sure? Hypothetically? Huh? What? Who? When? Where? Okay. So, all right. The result of our what's your verdict? The plaintiff may be able to bring an action against both drivers, both the one who cut her off and the driver who rear-ended her. Okay? Both of them were negligently acting. Now, the guy who cut her off in our example, he didn't actually ever touch her car. He never caused damage to her car, but he could potentially still be held negligent, held responsible, because his actions led her to slam on her brakes, and then led the other guy to hit her car from behind. Okay? So we have, you have this idea that everybody needs to be responsible for their own vehicle, for their own, their own care. Yes. The first driver, the driver who cut her off, could be potentially responsible in addition to the guy who hit her from behind. Okay, so both parties could be responsible here, and then we have money in the background because it all comes down to money. If her insurance company is looking to get some money from the guy who cut her off, in addition to the guy who hit her car, okay, they're going to get, have deeper pockets to pull from. Okay, so we have elements of negligent actions. Okay, the defendant must be owed a duty, or must owe a duty, must have owed a duty to the plaintiff. The defendant must have violated that duty, and the plaintiff must suffer injury as a result of the violation. And the injury must be foreseeable. I know these are excellent drawings I'm doing here. This is supposed to be a truck. Maybe I will be. Okay. And this guy's on his cell phone. It's on his cell phone. Okay. So in our example, the defendant, and here is the plaintiff. This is our plaintiff. This is the lady. She's a girl. Okay, this is the plaintiff. So she's driving along. She's going this way. Okay? And this guy is one of the defendants here. He owes her a duty. He swipes. He goes through the stop sign. All right, this guy cuts in front of her and goes through the stop sign. Then he keeps going. He doesn't get hit here. Okay? He just keeps driving down the road, or the sidewalk as it appears to be in this drawing that I've done. But he goes on. Now, she has to slam on her brakes. And when she does that, this car, this truck behind her hits her, okay, causing the damage. So we have a defendant who owed the duty to the plaintiff. We have a second defendant here who owed a duty to the plaintiff. Both drivers are responsible, or I should say all three drivers are responsible for being in control of their vehicle and being able to stop and control their vehicle to prevent an accident. Okay? He violated a law, so he was negligent, and this guy was just not paying attention. Okay? Our injury here, so we have duty that's owed, we have a violation of the duty, and then we have the injury that is suffered as a result. Now, is she physically injured? No, she's fine. Her car is the injury. Her car is damaged as a result of the defendant's violation. Okay, now, could you reasonably, and when I say you, I mean the hypothetical person, reasonably foresee this happening in this scenario? Could you see that how this guy, when he ran the stop sign, it could potentially cause an accident? Can you see that? Can you guess that that would happen? Okay. Now, let's say Aaron brings a packet of almonds to school, and he has the nuts in his, the packet of almonds, peanuts, whatever, tree nuts, in his book bag, and he leaves them in the classroom, and a little bit of the nut dust gets on the desk, and the next student who comes in is highly allergic to the nuts and dies as a result of the allergy. Okay? Who would be responsible for that? Is that foreseeable, is my question. Is that foreseeable that something Aaron did pretty innocently resulted in the death of this other student? Is that foreseeable? Is that something that you thought, that is in the realm of possibility when you were getting ready for school and you grabbed your package of peanuts? No. Okay? So it is not a foreseeable thing. Now, it doesn't necessarily mean that there would be no liability, but the liability would be much harder to prove. Aaron has a duty of care to make sure that the people around him are safe. However, there is no thing that we have in our school policy that limits him from having a snack in his book bag. Okay? There is a policy that limits him from eating it in class. So if he ate that snack in class, who would then be responsible? Me. Okay? For allowing him to eat the snack that then potentially, or that then did cause the death of the next student who came in. Okay? Now, is it reasonable to expect or to assume that a snack being eaten in class could cause the death of another student? No, not really. So that's kind of a stretch. But do you see the difference? Where this guy ran a stop sign, it is very easy to see how that could have caused an accident. My other example is kind of a stretch. Okay? There may be liability there. However, I do not think the liability would fall on Aaron or Aaron's shoulders. It would maybe come back to me, to the school, to our policy, something like that. Maybe our nursing staff for not having an EpiPen available. That student who died might himself have been contributorily negligent for not having his EpiPen available. Okay, if you know that you're allergic to peanuts or highly allergic to nuts and you don't have an EpiPen available. Anyway, okay. Do you understand the elements of a negligent action? All right, somebody give me, take 3 minutes on this piece of paper and write down some example. Some example, not involving a car, Tell me what the duty was that was owed, what the breach of duty is, okay? Um, and the injury that occurs, and whether or not it was reasonably foreseeable. You can make it wild if you want. I'll give you 3 minutes. So, foreseeable is whether or not you could imagine or envision this happening. All right. So, example number 1, Nick. Can you just read briefly your example?
Okay. A man is playing golf and he hits his ball into someone else's eye that is walking by.
Okay. Where is he playing golf? Okay, he's playing golf on a golf course. The guy playing golf is on a golf course and he hits the ball. It hits the eye of a passerby. Okay. Do we have a duty of care? Okay. Do we have a duty of care here? So the guy playing golf, does he owe the people around him a duty of care? No, not necessarily. Not out on the field. Okay. So the duty of care is to the people. Oh, that's sad. That makes me sad. Okay, the duty of care here would be owed to the man who the people behind him. Okay, not on the driving range. He does not have to make sure he's not hitting anyone because that's why he's at a driving range. Okay, the guy who was walking in front or in the unsafe zone, that's his fault. Okay, so we have an example of contributory negligence, which we'll talk about in a minute here. There was no duty of care owed, so there can't be a breach of duty. So even though there is an injury, all right, even though we have a damage to his eye, and it is foreseeable, okay, if you walk in front of somebody who's driving golf balls, you can see it's probably going to end poorly. Okay, now, let's take them off of the golf course and let's put them in his backyard. And he lives in a neighborhood. And he's driving golf balls, and there are kids playing in the next street over. And he's driving golf balls in that direction. Okay? Does he have a duty of care there? He absolutely does. He has a duty of care not to hit the golf ball and invade the safety or the privacy, whatever, of other people. Okay, so he does have a duty of care. If he hits them, does he breach that duty? Is he breaching that duty by hitting golf balls? Yes, he is. Okay, is there actual injury? I don't know. Let's say he breaks a window and he, hits a little girl in the head or something. Okay, yes, injury. That's awful. Foreseeable? Yes, it is foreseeable. We could imagine that would happen if someone's driving golf balls in a local, in a locality, municipality. Okay, so that's why we have driving ranges and not just, driving golf balls in your neighborhood. All right, good example. Give us your story.
Passing baseball in the street. One kid threw the ball, and the kid's a random guy walking by.
Okay, kids are passing the baseball on the street. They're just passing. They're just tossing the baseball. Okay, they're throwing the baseball on the street, and a guy walks by and hits him. And what happens to him? It is damage. It falls off. Okay, it's a very powerful. Okay, he gets hit in the head and he receives a concussion or something. He's out of work for a week because of it. Okay, so we have kids playing baseball in their street. Okay, do we have a duty of care? Do those kids owe their neighbors and the people that live in that location? Do they owe them a duty of care? Yes, okay, a duty not to invade their space and injure them. Okay, they are, and who more specifically than the kids, who owes that duty of care? Whose responsibility might it be to tell those kids not a good idea? Well, the parents. Okay, the parents. It would be their responsibility to say, hey guys, probably not a good idea to play baseball right here in the street. People are walking. Now, the guy is walking down the sidewalk. Did he do anything wrong? No, he's just walking down the sidewalk, okay? So there is a breach of duty by them playing the game And the injury that's sustained here, there's our actual injury. Is this foreseeable? Okay, if you're playing baseball on a street and there's other people walking around and, you know, people that could be injured, is it foreseeable that someone could be hit? Absolutely, okay? So we have our foreseeability test here. So then we do have proximate cause. We do have a tort here. Okay, that guy could potentially go and sue the people, you know, to get the money for the time that he missed in work, or, you know, if he doesn't have insurance, they could pay for his medical bills, that kind of thing. Okay? Rob, last one. Hold on.
What? My example? Oh, duty to rescue says that you have to at least report if things like you see someone get beat up or raped or something.
Okay.
Have to at least report it.
Okay. So we have a duty to report. Now, what's our example? Is somebody being hurt?
Yeah, somebody being beat up.
He's being beaten up. Okay.
And you see.
So there is the duty of care is that we must report. It's also that someone should not be beating the other person up. Breach of duty would be the person being beaten up. Injury would be the injury sustained there. Is it foreseeable? Yeah. Okay. Good enough. All right. So here's our formula. If we have duty and we have breach and we have causation, okay, and we have damages and we have negligence and we have a tort. All right. We find torts by a preponderance of the evidence. Remember, in criminal law, we said it had to be beyond a reasonable doubt. Remember that whole talk? Had to be beyond any other doubt. You had to be almost 100% sure that this was the only way this could have happened, right? Okay, we don't have that here. You just have to be just a little more sure, okay, by a preponderance of the evidence. So we just have to have one side be a little bit more sure than the other side, and therefore we have a preponderance of the evidence. So when we talk about jury cases, which we'll talk about in a while, you don't have to have a unanimous jury. You just have to have some of the jurors believe you, or more than the others that don't. Okay, so that is our standard of proof that must be met in order to win a civil case. Okay, preponderance of the evidence. Got it? Big word, simple meaning. Preponderance, a little bit more. All right, so we have here two examples. These are just kind of funny examples of proximate cause, okay? It says, I still can't believe lawyers sued. Oh, wait a minute. This is not. That should be in the other order. Gross negligence. This is our next concept, okay? Gross negligence is a type of negligence which is so reckless, okay, with such lack of consideration for other people's care that we call it gross negligence. It's just gross. Okay. Ordinary negligence would be the examples that you guys gave. Hitting a ball, and it is an accident situation. Yes, you could see how, you know, running around a pool, you might fall, slip and fall and get injured, or running a stop sign, you know, that kind of thing. However, gross negligence is when it's a substantial lack of concern, and we have to separate the two. Okay, so we have this cartoon here says, loose mortar, no warning signs. Okay, Mr. Dumpty, you are a victim of gross negligence. Okay, in other words, the wall is crumbling as you're sitting on top of it and you fall and you crack your head open, as in Humpty Dumpty. Okay? They're saying that there was some kind of negligence, some gross negligence here, because the wall was not properly maintained. So it's not just an accident. He didn't just fall off of the wall. He fell because the wall was not properly maintained and there were no warning signs to tell him that he should be careful. Okay. So that's gross negligence. Maybe. There we go. These are some pictures of an oil disaster. Okay, the Deep Horizon, the Deepwater oil rig disaster. This is the oil that is washed up um, along the shores, and this is all the massive damage that was caused by gross negligence. Okay, that was the cause of that was negligence on the part of the company, poorly maintained oil rigs and things like that. There was negligence happening on the part of the I think Deep Horizon, Blue Horizon. Anyway, the oil spill. Okay, as a result of the negligence here. And then here are some of the injuries. So the injury is not just what's happening here, where the oil is in the water and there's this huge explosion and lives were lost. It is also these mutants from the Gulf. Okay, we have a 400-pound catch of eyeless shrimp. Okay, we have shrimp with tumors and we have fish with lesions. We have extensive damage that extends out beyond just the the immediate occurrence. Okay, so this is our gross negligence. It is so reckless. It demonstrates such a lack of concern for others. It is automatically up to gross negligence. Okay, we have negligence in children. Minors are held to different standards of care than adults. Okay, minors' negligence is evaluated against what a reasonably careful person of the same age would do with the same mental capacity and the same circumstances. Okay, and very young minors under the age of 7 are typically presumed to be incapable of negligence. These children here, they're my children, some of them, everyone but that one. That one's my nephew. But these children here are all under the age of 7. Okay, so none of these children here could really be held responsible for negligence. This one is not 10. He is 7 in this picture. He's so cute, but he's 7. Anyway, and a lot of times he reminds me of you. It's funny. You remind me of a 7-year-old. I'm just kidding. Anyway, but so these are very young children. They are not responsible or could not be responsible for negligent actions. However, they do things that, kids do things that are negligent. So you guys, this group of teenagers, y'all do just really, really, really not smart things. And we have to wonder, could we foreseeably assume, things, bad things could happen as a result? I just watched a terrible show about all kinds of tragic things that happened. But one of the things was the people that die every year as a result of projectiles being thrown or people that are injured. There was a prank that was going around. It was a couple of years ago, probably 10 years now. Kids threw a frozen turkey, out from they were standing on the side of the road and they threw it at a car. That turkey landed and it hit like a bowling ball. It came in at the driver's face and it hit the steering wheel, thankfully, first. It came in with 80-mile-an-hour force and it crushed her face. Every bone in her face was broken. Okay, as a result, she lost eyesight. It was this terrible, terrible tragedy. But could the kids have foreseen that would occur? Okay, were those teenagers, I think they were 13, 14, 15 years old, were they able to see They knew, yes, they had a duty to not throw an object at a car, okay, an object like an egg. They knew that they had a duty there, and they breached that duty. But were they able to foresee that throwing an object like a frozen turkey would have caused this kind of damage? What do you think? I'm asking you. Do you think that they were able to foresee that it would cause this kind of damage? What do you think that those teenagers thought would happen? It would hit the car, and they thought maybe it would smash a window, and maybe she'd veer off the road. I'm not sure what they thought, because they're kids, and God knows what goes on in your heads. Okay? It's a scary place in a teenager's head. But the take-home point here is somebody, somewhere, you have to find a way to listen to that little voice in the back of your head going, maybe this isn't a good idea. Okay? Because the results were tragic. And the boy who actually threw the turkey, okay, he was sentenced to 3 years in jail. Now, I don't know if that's fair, if it's right, if it's wrong. This woman's entire life was changed. I should get you a picture of it. Terrible, very, very, very tragic. But the question is, are kids able to see? Are they able to make these kind of judgment calls? So we have this reasonably careful person, but we have to use a reasonably careful teenager as our standard. Okay? So we're going to say, Aaron is a pretty good example of a reasonably careful person. We would compare him to Rob, who is just bat poop crazy, okay? And say, Rob, you really stepped over the line here. The average teenager would be reasonably able to see this, not being a good idea. And then we also have the idea of parents should be involved. So if my kid threw a frozen turkey off of an overpass and killed somebody in a car, okay, this one who's big enough and strong enough to pick it up and come up with the idea, what would that 7-year-old be doing on an overpass alone with a frozen turkey? Okay? It would be my responsibility. That would be unreasonable to think that a child of that age would be able to do all of this stuff without the parents being, a party to it. It is not quite so unreasonable to think that 13, 14, 15-year-olds would be able to hatch the plan and make it come together, toilet papering a house, throwing eggs at cars, that kind of thing. Kids do those kinds of things. This would be just taking it one step further. Do you understand how scary it is that y'all are out there making these terrible decisions and we're not there to help you? Dear God, help us all. Okay, so that's children and negligence. All right, here it is. This is, I thought, something, whatever. A community in Florida was moving to ban children from playing in the cul-de-sac, and I think I have a link here. The minor children must be under direct control of a responsible adult at all times. Items such as skateboards, big wheels, loud or obnoxious toys are prohibited. So this community was trying to ban these kids from being able to play because they are saying children are not able to make good decisions such as not rushing out into traffic or, whatever. People were parking. They said, would you drop your children off and allow them to play at a Walmart parking lot? Okay, probably not. So they were saying this is, it's not a playground. It is a thoroughfare where people are driving, parking, whatever. And the responsibility should not have to be, in that case, on the drivers. But it becomes that you have an elevated responsibility knowing the kids are there. When you enter a parking lot of a school, any school, including this school, okay, we have to be, the responsibility is on the driver to expect some nutty teenager to dart out in front of you. So we are on the defensive as a driver in a high school or an elementary school parking lot. Okay, that's why we have school zones, to protect the nut job kids in a nice way. In a nice way. Okay, So now we're going into the idea of comparative negligence and contributory negligence. I'm just going to skip ahead to contributory first. Contributory is if the plaintiff is in any way contributing to his or her own injury, the plaintiff is barred from recovering damages. Nick, your example was perfect for this. Guy walking on the driving range, not a great idea. He is responsible for his own injuries as a result of walking on the driving range where it was likely posted that he should not be on the driving range. I have another picture, don't have it up here, but of a guy. He has 3 ladders and 2 chairs on top of a ladder, and then he's standing on a paint bucket to reach something. Not appropriate use of a ladder. He has no one to blame in that situation except for himself. Okay, when I stand up on these things, okay, to hang something up, if I fall down, I cannot sue the school. I can't sue this file cabinet company because it is not meant for standing. Okay, that's contributory negligence. All right, moving backwards. You're fine. Comparative negligence. This is when the damages, okay, for a plaintiff are awarded, but they're reduced in proportion with the plaintiff's fault for his own injuries. Okay, so if the judge says a plaintiff should get $100,000, but he finds the plaintiff is 40% at fault, the judgment would be switched or lowered to $60,000. Okay, here is the actual example. Jaywalking. So a common example, comparative negligence, when a pedestrian negligently jaywalks, which is when you walk somewhere that there is no street crossing, which I'm sure you've done before. I know I've done. I was in New York City. I jaywalked several times while I was there. But they take it very seriously in New York City. I'm sure, Ms. Brown, you can attest to this, because when you are jaywalking in the city, it's different than jaywalking here in Harrisburg. Well, I guess maybe in Harrisburg, but they will hit you. They will not stop, okay? When you are driving in New York City and you stop for someone who starts to jaywalk, you are then putting people behind you and in front of you in danger because no one is going to stop. The traffic does not stop, okay? So jaywalking is a much more serious thing in New York City than it is in Lemoyne, okay? If you start to walk out in the middle of the street in Lemoyne, everyone stops. And they can then let you go, and they might say, hey, that's it, okay? In New York City, they will hit you. They will run you over, and they will not stop. And then 6 other people will run you over. Okay, so we have this picture here. We have these guys walking across the street here, and one of these cars clips them as they walk. Okay, the driver might be held liable for the broken leg and the missed work, but only to a point, because this guy was doing something that was foolish. He was walking in a not in a crosswalk, and he didn't wait for the little, blue arrow, green guy, whatever it is, the go-ahead guy. Okay, so this is comparative negligence. So we would reduce the amount that the driver would be responsible for by the amount that the plaintiff is responsible for. Do you understand this? Will you be able to explain this to me using your own example? I don't know. We'll see. So we're going to take about 5 minutes here. You're going to write an example for me, and you're going to use this comparative negligence idea and tell me if there is comparative negligence and how it would be affected. Okay, so I want you to go back this way, back to our sample example. Okay, and we're going to add a category here: duty of care, breach of duty, injury. Is it foreseeable, and is there any comparative or contributory negligence? Okay, I want you to do this now. I'll give you about 5 minutes, and then we'll come back together and discuss. Okay, so examples, we're looking for comparative, contributor, and negligence. What did we come up with? Example. Aaron, you want to go first?
Just walk outside and he thinks they get across the sidewalk to where the cars going,
Okay.
they rush across
Okay.
the street, the car speeds up.
The car speeds up and hits him.
Like, well,
Just normal speed. Okay. So a guy thinks he's gonna make it across the street and jaywalks.
they allow the car.
Okay, runs out in the middle. The car is coming. Car hits him. Okay, we have contributory or comparative. Contributory means he gets nothing as a result of the injuries, or comparative means he gets a part. So it's still the car's fault for hitting him. However, it's also his fault. So which one do we have here? Contributory means he gets nothing.
Because he's the one who does his fault every
Okay. All right, Aaron is a tough one. All right, do we have a duty of care? Yes. Okay. The car needs to be aware of its surroundings and not hit other people. Okay, so we have a breach of duty in the hitting. Injury, one would assume when a person's been hit by a car, there is some injury. Okay, to them or to the driver. Good, okay? And in that case, we can go back and say if the driver was injured as a result of this accident, we could go back and say the duty of care would have been on the man to not jaywalk and cut in front. Okay, was this foreseeable? Could a reasonable person look at this situation and say an injury could result as, okay, be sustained as a result of these actions? Good, all right. Another example here, Nick.
I don't know if this is one of it, but
Okay.
says Dan is making a left turn and hits Ann, who is driving over the speed limit through the intersection. Ann sustains injury and sues Dan, or Ann sustains injury and sues Dan for negligence. Under a
Comparative.
negligent system, Dan may be found to be 80% at fault for hitting someone while making a left turn,
Okay.
and says that Dan may be 20% at fault if he is speeding.
Okay, so we have two people. It's all in an automobile accident. Left-hand turns are, especially if there are certain places where left-hand turns are actually prohibited. There's a sign, but left-hand turns do require additional responsibility when you're making a left-hand turn when you're driving. So the 80% of the negligence would go into Dan, was it? Dan's category for having made the left-hand turn. However, Ann was speeding, so she is still partially responsible. So 20%. If she were the one who was the plaintiff and was filing for the damages, her damages would be reduced by 20%, and his damages would be obviously reduced by 80%. Likely that they would negate, and neither person would be entitled to anything. Okay. All right. Good examples. We are going to finish up here, maybe. Okay. And we're going to finish up here. Mixed comparative and contributory negligence. Some states follow a mixed comparative and contributory. So again, if it is more than 50% responsible. So in this case, in Nick's case, Dan was 80% responsible. He was more than 50% responsible. That would be considered contributory. He would get nothing. Okay, Ann was only 20% responsible. Therefore, she could claim, make a claim against Dan, but obviously subtract her 20% of responsibility here. So some states have this mixture. Some states, we have, in Pennsylvania, we have what's called a no-fault state. So that accidents, we don't have these kinds of lawsuits generally. All right. And last thing is vicarious responsibility. So this is when one person is held responsible for the negligence of another, typically in areas of employment. So the employer is the master. They're responsible for the negligent acts of the employee. Okay. And then the example would be an employer may be held liable for an accident caused by an employee as a result of negligent operation of a delivery vehicle. Okay? And under the same umbrella, parents can be held responsible for negligent acts of their children, which goes back to what we've discussed already with kids and making poor choices and parents being responsible for them. Okay, so that's the vicarious liability. And in this image, okay, if I told you this was an example of vicarious liability, what might be going on here, or what might be about to happen here? Just tell me, look at this image and give me an idea of what you think. If we're talking vicarious liability, what does that involve? Who is he and why would it be vicarious? Help me out. We're talking about vicarious liability, so we're looking oftentimes at an employer, okay, being responsible for the negligent acts of the employee. All right, and then we have this guy. So who might this guy be? If this is going to be an example of vicarious liability, who might this guy be? What might the story be here? Okay, he is drinking coffee and he is texting. Okay, but who and how would this be an example of vicarious? I'm telling you it's vicarious, so you got to make that connection for me. He is supposed to commit to the road, but who, if it's vicarious liability, okay, remember, look back at our definition of vicarious liability here, okay, in an employment context. Okay, so the employer is going to be responsible for the negligent acts of the employee, even though the employer might not be there. Okay, the employer might be liable for an accident caused by an employee as the result of the negligent operation of the vehicle or whatever the situation may be. This case, this guy he has to be working for someone. He has to be entrusted as an employee to drive the vehicle safely. Okay? He is texting here. He is drinking coffee. He is not operating the vehicle safely. He has been entrusted as a driver by his employer. Therefore, the deep pockets that they're going to, if he kills somebody, they're not going after this guy who looks to be like, 21. They're going after who? The employer. Okay, they're going after the employer. They are going to go for the person who has entrusted him with the responsibility of operating the vehicle. And, okay, do you understand vicarious liability? Nick, do you understand vicarious liability? Okay. All right. This is your assignment, okay, and I'll leave this up here. Before the end of the period, I want you to create an example of a negligent tort using some photographs, okay? You cannot use anything we've discussed in class, okay? So you have to come up with your very own brand new example, okay? Type up the example and the images. This should look something like our sketch here, where we list duty of care, breach of duty, injury, whether or not it was foreseeable, and if there was comparative or contributory negligence. There might not be comparative or contributory negligence. That's up to you. But you're going to use photographs that you find. Okay, it doesn't have to be one photograph. You can use Photoshop to create the image. Maybe a squirrel runs out in front of someone who's texting. They veer off the road. They crash into a house. They, whatever, explode the hot tub in the backyard. Now you can't use this example. You have to ask yourself, was that foreseeable that they would have done that? Is there a duty of care? Is there a breach of duty? So you need to create the image, create the idea, okay? The negligent tort example, using photographs and the concepts that we've discussed here, and then you're going to type it up, set it up, and then submit it. Questions? Comments? I'm looking for creativity and originality. Nothing we've discussed in class here. Got it? No versions of it. No woman jaywalking instead of a man, or woman golfing instead of a man. Brand new ideas. Got it? Got it? All right. And that concludes 5-3 negligent liability. I mean negligent torts.